Hello, everyone. Welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. Tonight we have, I don't know if it's part 8 or part 9. Darrell says it's part 9. I can only find part 7 in my files, so I don't know what happened to part 8, but I don't know. So we're either on 8 or 9, one or the other, but it's definitely a long, drawn-out nightmare that Darrell has gone through with all aspects of government, from the local all the way up to the feds, and how they use gang stalking to basically take what they want, take over what they want. And this can be on the whim of one person. And I have a little background music. It's Easter, and where I live now, we can have some fun. Nobody's gonna bat an eye. So, pretty cool. Anyway, Darrell just got a new computer, new router, new everything, and he was installing it right before the show. And he said he was logged on, but I couldn't find him. So he was, I don't know where he was at. So I said, had to email him a new link. So he's going to be delayed a moment. For one, he has a touchscreen computer. That's all he told me. And he doesn't have a mouse. So he doesn't know how to navigate by the touchscreen because he's never used one. So it could be a minute before Darrell gets here. It could not. I don't know. If you caught me yesterday, I did a show again, another show. I don't know, my 4th, 5th, 6th one. I've lost count. On Iran's deep underground military bases, or military cities as they call them, and how they are very well fortified with plenty of weapons. They've been planning this for decades, and they're way embedded. And you know how those people in the Middle East are. They're very difficult to extract from those mountainous regions. And, that's the cradle of civilization, right? Right there in Persia, Baghdad, all that area. So, yeah, it's not going to be no 2 to 3 week thing. And I'm sure you heard. I don't know if you guys don't follow Marjorie Taylor Greene. She's popped up. She's the former congresswoman and head cheerleader for the MAGA movement from Georgia, who quit. She's like, this is unacceptable, and I don't want to be a part of it. And she quit. So now she has her own YouTube channel, and she's been quite vociferous regarding the actions of Trump. And you want to talk about a 180, man. She's just really laid into it because finally, she decided I'm really going to look and I'm going to acknowledge these red flags that I see in front of my face that I've just been in denial and overlooking because I support, got Darrell backstage, support just out of full faith. And it's going to get us in trouble with these people. Listen, if you still believe politicians are going to save your hide, if anything, they're the ones going to take your hide. They're going to scalp you. They're going to skin you alive. Y'all just don't know. Y'all just don't know what these people are really, truly capable of. And again, a lot of them are minions, but for real, there's some wicked shit going on there. So good. I'm glad I got Darrell backstage. Give me a minute, Darrell. Oh, I don't want to share. Hang on. Yeah, these people one street over, they really like to have fun and party. They get bounce houses and for the kids. It's real fun. Kids are all out there screaming, hollering, yelling earlier. Oh, yeah, I need to go over here. All right, here is Ann LeFlore's On Trust books. These are discontinued, out of print. They will no longer be available. So get your copy before they're gone. $199. I have some soft covers in inventory, and once those are depleted, that's a wrap, folks. You will never see this book published again. We have the other one as well. We'll pop it up for you. And this is the Specialty Trust book. Same thing. This book is discontinued, out of print. Again, we have a few copies, physical copies. Once those are exhausted, that's a wrap. There will be no ebooks, no softcover books. There are no hardcovers anyway. So there you go. All right. I think I've paid the bills with pennies. And we have Darrell backstage. Oh, by the way, let me run this by you. This is the $1. There we go. This is the $1, 1 ounce of silver for one of Ann's books. So if you'd like to do that deal, pick up one of these soft covers for a silver $1. Hit me up, fearlessfloyd@yahoo.com. You can call me or text me, 9 to 9 Central Standard Time. And now we'll get into the Darrell Link story, part 8 or 9. It's debatable upon who you talk to. But Darrell's going to give you a brief introduction. I'm going to mute my mic for sure so you guys can hear Darrell. But he's going to give you just a little synopsis of the story from parts 1 through 8, we'll say. Just keep it simple. To give you a breakdown of exactly what Darrell, who he is, what he's gone through, and kind of where we're at today with part 9. We're also going to show you some pictures and some documents as well. So stay tuned for that. All right. You ready to get on the stage, Darrell?
Can you hear me?
Yes, we can, sir. How you doing?
We coming through pretty good, or do I need to talk louder?
Oh, no, you're fine. I just need to mute my mic and give you the stage, and we can move from there.
Okay, tell me when you're ready.
The floor is yours, sir.
Okay. Well, this all started back in 1994 when I got in a little bit of a financial bind where I lost a little bit of equity in the markets, and then I tried to work it out, and it was in the beginning of the year where I was trying to plant crops, and I bought a bunch of cattle, and then Production Credit Association, they moved to try to foreclose on me. And so I made an agreement with them that we'd give them half it in the spring and half it in the fall, or half it in the fall. Yeah, half it in the spring and the rest in the fall when I sold the cattle. And I signed the agreement, and I thought everything was good. I started selling a lot of grain. And the next thing, 2 weeks later, they moved and sued me in state court why they shouldn't immediately seize everything. And so I didn't know what to do, and I tried to mediate with them and stuff, and that didn't work. We had a mediation agreement, and so right at the last minute, the day of the trial that it was set up, I had to quit selling grain so I could prepare for this here lawsuit. And so once I got into a position where, I was ready to go to trial, I talked to several people, been through that and through the courts, and they said, well, once you go through there, they said you're going to get run over like a steamroller, and you're going to have to pick up the scraps and then just make your way through it. And I thought about that for a while, and the day of the trial, I went and I filed a Chapter 12 bankruptcy to stay the proceeding. And after I got in, that stayed it, and I did it the morning of the trial. I was about a half hour late, and they were all waiting for me, and they were geared up to take me down, and I filed that Chapter 12 bankruptcy into the court record, and I said, have a good day, and I walked out. And so after that, we got in and we tried to work out through doing a plan and stuff like that. And then I start learning about this here system that we didn't really have any money. All we were circulating is credit. We didn't have any courts. I mean, this was all a foreign jurisdiction. And I start learning about this here, and that I run into a man that started the North American Freedom Council, who basically worked for the Security Exchange for most of his life, Joe Holland. And so, he told me that if you file that plan and the schedules, he said, you've contracted into a foreign jurisdiction, and you'll have to, and you'll have to finish out the contract, which is normally 7 years. And I said, well, wow, I didn't really like what I was hearing. And he said, but you need to discharge the debt and, get rid of that obligation. So what I did is I tendered, or first I worked through this here, and then I tendered 3 basically money orders and public office money certificate. They were pending the determination of the substance of said money by the Attorney General as required by CFR 31 CFR 371. And so I tendered that and discharged it, and I asked this attorney to, get me dismissed out of bankruptcy and do whatever you have to do, just get me out. I want out. And so I got out, and this is where it started. And if you want to put up part 9, number 1, we went in and we got a order to dismiss, a dismissal and reservation of jurisdiction on certain matters in the bankruptcy court there in Sioux Falls, South Dakota. And if you want to put up part number 1, Floyd, where it says, the debtor's motion to dismiss, having come before the hearing before the court, Honorable Peter K. Eckert, who is a bar attorney, bankruptcy judge of the District of South Dakota, presiding at 9 a.m. Wednesday, September 7th, 1994. After notice of all creditors and parties in interest, they're appearing where debtor Darrell A. Link, a person, and through his counsel of record, Cecilia A. Grunwald, who is a bar attorney, also appearing before Douglas Kettering, another bar attorney, for Farmers Credit Services, Production Credit Association of the Midlands, and they were out of Yankton, South Dakota, and an officer of the said creditor, Wayne Williamson, who is special assets for Farm Credit or for Production Credit Association, and Terry Pendergrass appearing as attorney for the creditor, another bar attorney for the creditor Commercial State Bank of Wagner, South Dakota, and also appearing attorney, another bar attorney, Owen Whiff, representing Larry Schmeichel, who basically I give him some piece of ground as security as he attempted to help me. And so I just forfeited that over, and then the bankruptcy wanted to claim that, so he used an attorney to recover and protect that. So the only party in interest filing a written objection of the debtor of the motion is required by the notice of a hearing on debtor's motion to dismiss was Farm Credit Services, Production Credit Association of the Midlands. And go to A1. Court having reviewed the instant pleadings, taken judicial notice of all the pleadings in this case and hearing the arguments of counsel, and confirming onto the record by the debtor personally, is that his wish was to leave the bankruptcy court, the court of equity, and go into a court of law, and the court found that there was nothing in the record to interfere with debtor's right of dismissal. The court specifically found no existence of fraud on the debtor's part, and based upon the said findings, it is hereby ordered that the Chapter 12 case of the debtor is hereby dismissed and all property of the bankruptcy estate again vested in the debtor. And then there was some little bit of further ordered for the attorney fees, and then Farm Credit wanted to claim another $8,000 for a lien against the 94 crops. But before I go any further, I want to first of all, I want to give thanks to my Heavenly Father for the gift of eternal life and a conscience toward God and the desire to seek and serve His truth. I want to dedicate this presentation of events I experienced in my life to a great man, a friend, a true brother in Christ, a former pastor who had trouble with his voice box and had to retire from being a pastor. The late Ray Ehrman of Freeman, South Dakota. Ray studied law to help several of his local church congregations protect himself from losing their farms due to financial issues. Ray had a wonderful and a giving heart, along with his beautiful wife, Sharon. Ray was dedicated to standing against the abuse and power and corruption, with standing against it with truth and law. So we didn't have a computer at the time, but Ray was an excellent typer and a great at constructing documents, and it was really a blessing to be able to work with him. And he always made time to help when it was needed. And as I did have a typewriter, and so, but Ray lived out his faith and didn't wear his faith on his sleeve. A true servant of the Most High Creator God, who always made time to help others in times of need. I also dedicate a lot of what I learned from many other patriot community in the patriot community who stood strong against the abuse of power and corruption. Many of those bringing war against the peaceful American people are involved in secret societies like the state bar associations, working together with the Masonic filth, or better described as the Luciferian cult, promoting the New World Order, the one world Marxist communist agenda. Now, don't get me wrong, there's a lot of good people that get involved in the Masonic lodges, but don't really know who they serve at the higher degrees, the higher levels. So choose this day whom you will serve, but test the fruit. But what I'll be showing is proof of who is bringing this mixed war against the people, as farmers, as businessmen, etc. The court documents are evidence that the British accredited Regency or Bar Association, who are foreign agent attorneys and are using the courts for unjust enrichment and controlling our communities. These corporate agencies are operating with an EIN, to the employer identification number, and registration registered as for-profit corporations on Dun and Bradstreet. They are harvesting the energy of the people as human chattel identified as ins legis entities, legal fiction persons that were basically established by the pledging when your birth certificate was filed into the county record. And then it was put on bond paper and given a Dun and Bradstreet number, and it's been used as collateral for the public debt ever since. And you've heard the phrase that baby is as good as gold. And that's what happened in 1933 when they replaced the gold with the birth certificated persons, the legal fiction. And that's why they spell it in all capital letters, because it's basically corporate chattel that's being used to back the credit. Most banks, U.S. Marshals, most sheriffs and police all working together to unconstitutionally take private property without authority, due process of law, without a lawful warrant. You may know of secret societies like Masonic lodges, which are usually located near or even connected to the courthouses, involved in controlling the New World Order agenda with bar attorneys, bankers, corporate paid enforcement agencies, managing and controlling those who are willing to bend a knee to the corporation, to the corporate one world control agenda that's being forced upon the people today. So If you want to go to 1B, here we go. And what I did, after I was dismissed, I moved about 7 days later and I filed a non-judicial commercial lien process against everybody that was involved trying to steal substance, for trying to take substance for an issuance of credit. I filed a non-judicial commercial lien process, which Joe Holland knew how to put that together in against these people, where they had to respond by affidavit, and it was all done by affidavit under the penalty of perjury, and they had 30 days to refute it. So I served that on 58 parties, including the Bar Association of South Dakota, for $25 million each, and they had 30 days to rebut it by affidavit. And they didn't know what to do. And I served it, and I sent it in. I sent it out on the 7th day, and a lot of them got it on the 8th day, and they had an emergency hearing. I should have waited till after the 10th day, but I didn't know any better at the time. But so they moved to reinstate the dismissed bankruptcy. And so they moved to dismiss it, or to reinstate the dismissed bankruptcy. And of course, Judge Peter Eckert was named as a judge that was participating in this here, and he was he had a conflict of interest, and in spite of that, he went to vacate it anyway. So here's the order, and this was on this order to vacate was issued on the 25th of October. This is 1B. So here's an order to vacate dismissal entered September 29, 1994. That's where the same judge, Peter Eckert, basically stated that there was specifically no existence of fraud on my part, returned all the property back to me, and I was dismissed. And he, for restraining debtor from filing a non-judicial or filing judicial or non-judicial liens, transferring case to Chief Judge Irvin N. Hoyt. Now, there was no fraud, but what they were doing was using the bankruptcy court to protect themselves from liability for the fraud and corruption that they were involved in. And I stated all my statement by affidavit under the penalty of perjury, and I expected them to answer it point by point the same way. And they couldn't do it, so they had a problem. So they were, and I got this confession at the criminal trial when they charged me with concealing property later on. And the Chapter 12 bankruptcy trustee said, well, he said, you had these here documents out there, and we didn't know what to do. We feared that it would encumber all of our property, so we didn't have no other option but to reinstate the dismissed bankruptcy to gain control over it. So he confessed that under oath on the stand. So I'll read through this here. Order to vacate and expedite the hearing on Chapter 12 trustees' motion to vacate now that day, the courtroom normally had maybe one or two people, maybe three at the most, waiting in line to be in the chute for the next one after, for the next case. That day, the courtroom was standing room only. It was all full of people. They were suits and ties and all this here stuff. So that was all these people that were actually named on this here non-judicial proceeding. But the court is used as their defense. So this Chapter 12 trustees' motion to vacate, alter, amend, modified order of dismissal and reservation of jurisdiction on certain matters having come before the court on Friday, October 21st, 1994 at 9 a.m. before Honorable Peter K. Eckert, bankruptcy judge presiding in the bankruptcy courtroom, Federal Building and U.S. Courthouse, 400 South Phillips Avenue, Sioux Falls, South Dakota, and appearing Darrell Link, debtor pro se, Rick A. Noel, Chapter 12 bankruptcy trustee, and Douglas Kettering, attorney for PCA, Craig Peyton Gomar, pro se, or he was actually for a U.S. assistant U.S. attorney, and pro se Cecilia Grunwald, and she was the attorney that I had to help me do the paperwork because I didn't understand all the paperwork. And so she was listed on that non-judicial proceeding too, but all they had to do is respond. If they weren't guilty, all they had to do is respond by affidavit on the penalty of perjury. So the court, having testimony of Darrell Link, the exhibits offer into evidence with good cause appearing, therefore it is hereby ordered that the order of dismissal entered by the court on September 29, 1994 shall be the same as hereby vacated, and debtor 12 is hereby reinstated until further order of the court. And here is further ordered that pursuant to 11 U.S.C. 105, that the United States Bankruptcy Code, debtor Darrell A. Link is hereby restrained and prohibited from filing any judicial or non-judicial liens in any city, county, state, or federal government entity, office, and or agency for any amount pursuant to debtor's commercial affidavit of truth, notice of non-judicial proceeding, notice and warning of commercial grace, and statement of account, 3 counts, against any of the parties or entities listed on the lien debtors list, served by debtor upon the respective parties designated therein. And it is further ordered that in light of the impending retirement of the undersigned bankruptcy judge, this case shall be immediately and forthwith reassigned to Chief Bankruptcy Judge Urban N. Hoyt, who is another bar attorney, and this was dated the 25th day of October, 1994. Now, so what I did is go to 1C, and I filed an affidavit of revocation of and rescission of signature and power of attorney. And this was done on October 31st. So that was about 6 days later. And I filed this into the court record because I did not want to be in the bankruptcy after they vacated it. So to whom this may concern, the undersigned natural individual with full powers to contract, to rescind for non-applicability, non-qualification, and mistake, do hereby revoke and make void per UCC section 2-608 ab initio, that's from the beginning, all signatures on any and all instruments and any express implied power of attorney therewith, in fact or assumption, signed either by me or anyone acting as agent or undersigned as it pertains to the bankruptcy case number 94-40136, petition dated March 1st or 21st, 1984. There's always a cover sheet that got to be filed along with anything that gets filed into the court. And the declaration concerning debtor's schedule dated 4/23/1994, and the statement of financial affairs, Form 7, dated 4/22/1994. I further and the undersigned do hereby revoke, cancel, annul, repeal, dismiss, discharge, extract, withdraw, abrogate, recant, negate, strike, repudiate, wipe out, disavow, recall, renounce, destroy, abjure, disclaim, disown, reject, and relinquish all signatures and powers of attorney in or assumption with or without my consent and or knowledge as it pertains to any of the above mentioned documents, and the foregoing action is retroactive to the date of such signatures. I further state and notice that affidavit replaces, cancels, repudiates, and discharges the obligations, the nexus, the connections, existing in prior instruments listed above. This for discharge purposes, for any valuable consideration alleged, or the duty allegedly requested and expected, to put United States Bankruptcy Court back in its original position held prior to the signing of the above referenced instruments. Witnessed at my hand on the 31st day of October, 1994, and that was notarized, subscribed, and confirmed on the 31st day. So I had that filed the same day I had it notarized. And then I did on document 1D is a notice of rescission and discharge to whom it may concern. This is a notice that the enclosed affidavit discharges bankruptcy court from original obligation to perform, referenced as a valuable consideration in bankruptcy application dated March 21st, 1994. Thank you very much. Please take further notice that the affidavit of revocation and rescission of signature and power of attorney, all signatures are revoked retroactive to the date of signing, because I just recently found out that I had no right to be in your court and this bankruptcy unit based on the restrictions found in 11 USC 101-46, the District of Columbia, and 51, the territories and possessions of the United States, which is Puerto Rico, Guam, Virgin Islands, and American Samoa, and 11 USC 109A, where you must reside or domicile a place of business or property in the United States as defined in 11 USC 101-51. That is why I rescind the signatures on those documents and any related thereto, and put you back in what I believe you were before valuable consideration was petitioned for. I will give all parties space to show cause why the original petition should not be rescinded based on non-applicability, non-qualification, and mistake, as required by UCC 2-608 at number 2. The effect of this notice will become final in 30 days if no one brings forth any valid arguments to present same by affidavit. Thank you again, and God bless you. I signed it, Darrell Link, and this is certified, and I have a list of people that it was sent to. Now, anytime you go into a law book, you got the definitions of what it means, what the United States means, what state means, and what municipality means. And all these statutes and codes will always say United States means, it includes the District of Columbia, Guam, Puerto Rico, its territories, and insular possessions. Sometimes it'll have American Samoa, Virgin Islands, and stuff like that. But those are the only places those statutes apply. And they bring us in there through the warehousing of our birth certificate. When mother signed your birth certificate, she actually pledged you as collateral, is under the presumption, is what they did under the Emergency Banking Act in 1933. And this is the deception where they're using these unfair, deceptive acts and practices to hold us as bond slaves, chattel for the public debt. So, and here, go to number 2, where this was filed December 8th, 1994. And this is an order converting the case from a Chapter 12 to a Chapter 7. Now, I withdrew all my consent. I revoked and extended my signature on all the documents, and they weren't going to allow that. So they moved to compel me into an involuntary Chapter 7 bankruptcy. Now, involuntary Chapter 7 bankruptcy cannot be brought against the farmer because of the nature of his business, but according to their own rules, and that's what they did anyway. Above the title matter, having due before the hearing before the Honorable Bar Attorney Irvin N. Hoyt, United States Bankruptcy Judge. The old bar attorney is given loyalty to his little private club that they operate through. In the bankruptcy courtroom in the United States Courthouse located in Sioux Falls, South Dakota on the first day of December 1994 at the hour of 11:15 a.m. The debtor not appearing, nor being represented by counsel, creditor Production Credit Association through Wayne Williamson, who's the special assets guy, and his attorney Douglas Kettering. That was Kettering and Hosmer out of Yankton, South Dakota. Attorneys, bar attorneys at law. That means the law. And the court, having heard testimony, having received exhibits, having been duly advised in the premises, it is hereby ordered the judge to decree that the court finds that the debtor has committed fraud in connection with his Chapter 12 case by the sold property in the form of hay and straw that was not remitted of said funds, has tendered a fraudulent and false money order, has attempted to sell collateral indicating to the buyer that it was his, also as furnished in other fraudulent documents in an attempt to satisfy the obligation to PCA. And now what they're considering is straw and hay, anything that's gathered or produced after the bankruptcy is filed is not property of the bankruptcy estate. That was all new hay that was grown and straw that was grown in the year of 1994. And that's what I was trying to sell to do, and they charged me with 7 felonies, and they halted it. They sued me in state court, basically for selling property of a bankruptcy estate. And who was the victim? The chapter, or it was the henchman for the Chapter 7 trustee, Louis Dirks. He claimed to be the victim. So anyway. So here it was ordered, and these here money orders that were used, that were pending determination of the substance of said money, they were tendered to discharge the debt because we have no money in existence. And they were pending the determination of the substance of said money by the Attorney General, and the Attorney General didn't respond because there is no substance in the money. Credit is basically an obligation in the future. So this is all lies and deceit that they are using, but yet justified by our criminal justice system. And it is ordered and a judge and decreed that the dismissal would only benefit the debtor by allowing the further delay in paying creditors as possible. Dispense of assets. It is further ordered a judge and decreed that this case shall be converted to a Chapter 7, ordered on the 7th day. Now I withdrew all my consent, so why would I show up if I no longer consented to their jurisdiction? But they went ahead anyway and converted it and compelled it. So I wasn't aware of what happened because I didn't go to the hearing that day. And those instruments that were used to discharge the debt, Judge Peter Eckert, those were all into the court record. And so he ordered that there was specifically no existence of fraud. And you noticed in the reinstatement of the bankruptcy, he never talked about any of those instruments. The only thing he talked about was restraining me from filing any more commercial liens, judicial or non-judicial, against any of those parties. So he was using the courts to do it. And here this order on the 7th is, again, signed by Irvin N. Hoyt, Chief Judge of the Bankruptcy Court, attorney. And I can tell you some stories about him that weren't good using this little white powder. But anyway, that is hearsay because I only heard it secondhand from somebody that was dating his daughter. But anyway, on 2B, this is Irvin N. Hoyt again. He ordered allowing the trustee to gather and sale cattle. Now, this was dated the next day after he signed that. He says, this matter having come before the court pursuant to interim trustee ex parte motion for this court's order for ordering or allowing the trustee to gather and sale cattle owned and possessed by the above named debtor, requesting that no notice of such be required in view of the filings which have been made by the debtor herein, and the court having reviewed such motion and being familiar with the premises, the court finding good cause, therefore it is hereby ordered that the duly appointed trustee herein be allowed to gather and sale cattle owned or possessed by the above named debtor for the sale of the public auction, and it is further ordered that no notice of this order be required in view of the filings which have been made by the debtor herein, and it is further ordered that the duly appointed trustee account of this court for all the expenses proceeds realized from the gathering of the sale of cattle of the same. And this is dated the 8th of January. And remember, look it up at the top who the defendant party is, or who the debtor party is. They got my name, and when I asked to be dismissed, they start putting the Social Security underneath that name. So look at your Social Security card and look on the back of that Social Security card. It says this card belongs to the Social Security Administration. You must return it if we ask for it. So that Social Security card and that number does not belong to you. It belongs to this estate that was created. And so this is some more deception by the system itself. So they went ahead and that was in part 8 where I show the pictures and everything, how all these here different agencies work together. They come out and swatted me, encircling me with the number of cars and laying their AR-15s over the hood. In the trial, I told them, I said they had machine guns, and they said no, they weren't machine guns, they were AR-15s. So okay, thanks for making clarity on that. And I had 2 marshals standing at the front door with shooting glasses on, with their gun hands on their holsters. But it was 0 out that day on the December 12th. And the day before, this was on the 13th of December, on the day before, after I found out they had this here conversion, I filed an injunction. And I share that in part number 8, where I filed an injunction to this here to stop this here sale, so this can be worked out before any further damage is done. And I had that served by the deputy sheriff there from the sheriff in Minnehaha County. And he took it down and he served the court in the John B. Jones in the district court to halt this on the day before they come out and seize the cattle. And I've got that order, and it shows shown in part 8 where he denied the order. He denied the deal. But the first time when I went in there, I went up to the marshal's office up on the 2nd floor. And I walked up in there and I went to the secretary. I said I would like the marshals to serve these here papers on, Judge John B. Jones. And well, she went and got them, or hit a buzzer button. The next thing, these 4 marshals come out. And I said, I would like you to serve these documents, this injunction, on the court and on the district court judge. And they looked at those papers, looked at me, they looked at those papers, and looked at me again, and he said, we cannot serve these documents. Wow. Because they were planning on coming out to the farm and participating in stealing the cattle the next morning. So this is why I had to go to the sheriff's office and had to have them serve it. And so I show all that in part number 8. But then after they took the cattle, I served the proof of loss, because I had all this here insured with the Smith Farm Mutual Insurance Company. So I turned in a claim. I called them up and I turned in a claim that there was a theft, an act of vandalism, which occurred at 10 o'clock on the 13th day of December. Because they were stolen cattle. They had no authority to be out there. So by personal property described, the policy was stolen, or the policy, it was stolen or damaged in the amount of, I claimed $210,000. And because I already had those cattle sold, and anyway, so that's what I estimated their value was at the time. And the assured is sustained an actual loss, and I claimed $162.50 a head, and then 4 limousine bulls that were stolen. They had 5 semi-loads that come and haul them away. And then I had this Uh, he sent me this here, this proof of loss. He come out the next day, and he handed me this here, and so I went and I had it notarized here. I signed it on the 15th, and so then on January, the 15th of December, which is 2 days after they took the cattle. And go to number 4. We'll go to a letter that was that I sent to the Smith Farm Mutual Insurance Company, their agent, Mr. Walter. This is a response to your letter of December 28, 1994, wherein you state that your investigation reveals that the cattle were actually legally repossessed on December 13, 1994. You came to that conclusion based upon an alleged order allowing trustee to gather and sale cattle of the debtor. This document is defective on the following grounds. Number 1, first, the alleged order had falsely identified me as the debtor when I had withdrawn my application to the bankruptcy court. Number 2, second, Irvin N. Hoyt, our attorney, chief judge, had no consent or authority to make decisions regarding my property. Number 3, third, alleged order. It does not authorize the selling of any cattle or the seizure of any property warrant. 4, the alleged order does not authorize any seizure of property without due process of law. This means that if the alleged trustee wanted to gather any property, he had to gain consent to sue for it in state court. None of these were done. Now that's what I wanted to do. I wanted them to come and sue me in state court regarding those instruments, because the Constitution says in Article 1, Section 10, Clause 1, that no state shall make anything but gold or silver coin a lawful tender for payment of debt. So we would be able to talk about the substance of the said money in state court, and they couldn't do that. So they had to go the rogue route. And so 5th, the Constitution requires that no one should take any property without due process of law, without a warrant, that is supported by oath or affirmation, and specifically a description of the property to be seized, which the thieves did not have. That is why your company is liable for the loss of the insurance agreement that I have with your company. The reason why I state all of this is to show that your statement that they legally repossess some property is false. Also, the statement that the order gives authority to the trustee to gather and sale cattle owned or possessed by me is also false and misleading, in that the order did not say that they could steal property without consent, seize property without a warrant, or sell any property. You know, they sold the property taken. That was beyond the alleged court order. The thieves need to be prosecuted, and your company needs to pay the loss. You state that the trustees exercised his lawful authority. How can you say that? He had none. Besides, the trustee was not involved in the theft. The names I gave you did not include any trustee name. You see, the people that stole the property had no authority from any judge. Under any circumstances, the alleged order does not authorize delegating anybody else, does it? I wait for your response to this letter with a check in the amount of $210,000. Sincerely. And then I carbon copy the Sioux County Sheriff in Orange City, Iowa. That morning when they called the cattle out, I called the sheriff's office in Orange County in Iowa, and I told them that they had 5 semi-loads of stolen cattle coming their way and that they needed to be turned around, and I give them all the marking of the truck I would know. And I also had a some guys from this here, they called themselves the Gregory Militia. I did not know these people from Adam. They come in camouflage suits and an old Chevy car, probably about a '69 Chevy, and come dressed up, and they claim to be the militia. And the first person that they went to talk to is the lead marshal, Kevin Johnson. And so they come there, and this is after kind of after they were while they were loading cattle and stuff. And so what I did is I wrote a quick letter giving notice to the Sioux Center Livestock, which is a dairy sale going to happen the next day. And I did an overnight registered letter to the sale barn, which was rejected because I was going to give them notice that those cattle were stolen cattle and they were not to sell them, and they were to return them. I got that letter back, returned unopened, and still have it to this day. So we go on. Where was I at here? Okay, in this letter. Okay, here's the letter. This is the letter I was talking about in my response on January 2nd. This here letter that he wrote was from December 14th, 1994, which was the next day after the seizure of the cattle. On December 14th, Now, this letter was sent to the Division of Criminal Investigation and provided the information which was later included in a federal indictment against me. Now, December 14, 1994, we received a loss report from Darrell Link in regards to 192 cows missing and 4 miscellaneous bulls, 4 limousine bulls that had been stolen from his yard. In the report, he stated that he had witnesses. He also stated in that report that the theft had occurred on December 13, 1994. And December 15, 1994, December 15, 1994, I drove down to Darrell Link residence to investigate the loss. Upon arriving in the yard, I noticed that there was a few head of cattle in the corrals at this time. So I knew all the cattle had not been taken. I had tried to contact the loan agency on my way down to the Link Farm, and the loan agency was Production Credit Association of Yankton, South Dakota. And the person in charge was Wayne Williamson, Special Assets. I had no success in reaching Mr. Williamson by phone prior to the visiting with Mr. Link. Now, those few head of cattle that were in the yard yet were, I let my nephew have 60 head, and I was feeding them for him, and I expected him to kind of help to start farming. So they left those cattle there. And after visiting with Mr. Link for a few moments, it was quite apparent to me that the cattle had been repossessed. He kept pressing the issue as to the theft charges, and I told him I could not continue with the theft investigation until he had filled out the proper papers. And at the time, I presented him with the proof of loss and filled out, which he did. And that was one I just previously shared. At that point, he also supplied me with a list of several law enforcement people who had been present, along with the bank officers who repossessed the cattle. He told me that he and the militia would gather together in Yankton and have a trial of these people, and if found guilty, they would take them out, shoot them. He continued on with quite a distortion of the posse comitatus literature and gave copies of their reasoning for the illegal acts and the theft claim, and he was submitting to me. I gathered all the information that he wanted to give me and told him that I would with him in the near future. That was just a big fat lie. because I never talked about anything like that, but I did give him the name of all the parties that were involved. And I shared with him the lack of authority that they had in the bankruptcy court. And that the bankruptcy court that the case was dismissed, and I revoked and rescinded my signature. I did share all that with him. December 16th, 1994, which is a day later, he goes, I then contacted Mr. Leon Dirks, who's another bar attorney, in charge of the bankruptcy proceedings, and I also inquired about the legal document which substantiate the legal repossession of Mr. Link's cattle. Next page, 4B. At that time, I informed Mr. Dirks of the conversation with Darrell Link in regards to of the people in charge of the repossession, and that he was going to try them and then execute them if found guilty. Another big lie. I mean, this was Louis Dirks. He was the Chapter 7 henchman for the thief. He was the thief in charge underneath the Chapter 7 trustee. Put it that way. The December 28th, 2094. On December 28, 1994, after receiving the proper documents, I mailed a copy of that document from the United States Bankruptcy Court along with the letter dated December 28 to Darrell Link denying any coverage for theft in his case. Shortly after sending that letter, I was contacted by the DCI, the Criminal Investigation Office, in regards to my conversation with Darrell Link on December 15th. January 2nd, 1995, we received the second request from Mr. Link in regards to his theft claim. And again, we sent another denial letter dated January 17th, 1995, stating our possession. Again, that demand for payment would not be honored because this was a legal repossession and not a theft. Now, there was all kinds of rumors that went around that this one guy, they kind of get together on a Saturday and they were in a little cafe, and I don't know who was all there by name, but anyway, he said, one guy said, well, Darrell took the swing at the judge and he said he was going to shoot all these people. And that guy said, that's a bunch of garbage. He said, I know Darrell, and he said he would never say anything like that. He'd definitely not do anything like that, and that stopped that rumor. But after I got out of the space program or the prison, I come by and my neighbor who I farmed with and went to Sunday school with and farmed across the road from, went to the same church. He was fixing fence in the spring of the year. This is after I got my first truck driving job, and I stopped by and I go, well, how you doing, Steve? I said, it's been a long time since I talked to you. And he said, what the hell are you doing? Pulling guns on these people and threatening to kill them and all this stuff. I said, what? I said, where did you hear that? I said, I never as much as raised my voice. Mind pulling guns on them. I said, where did you hear that? Well, that's a rumor going around town. Wow. I mean, it's sure nice to have really things talked about. But anyway, going to number 5. Here was the notice of proposed action, sale of personal property. It's not proposed action sale, not selling, but the sale of the estate by public auction. The estate. It's not me. It's the state. Everything that was on tied to my 1040 forms when I had the depreciation schedule, and on that depreciation schedule it listed all the equipment, and everything that was on that depreciation schedule they claimed as property of the estate. That's for that dead entity that is attached to that Social Security number. And this is how they're taking over farms and taking over properties and holding us to all this mortgage on credit that belongs to you, because your signature is the credit. Your signature recognizes the energy that stands behind that name. And that name in all capital letters is basically a transmitting utility. It is an entity that's used as collateral for the public debt. That credit belongs to us. That credit is ours. When we put our signature on it, that is the value. That is the only value. You can go to the manual, the Federal Reserve manual, and it'll say the Federal Reserve notes have zero value. There is no value in a Federal Reserve note, but that's what we use as confidence, but it's deceived the people. They used to say a gold demand certificate or a silver demand certificate. 1 ounce of silver used to be $20, and an ounce of gold or an ounce of silver was $1. It was 371 grains, but no longer. So in this here document, to all parties in interest, you'll please take notice. Now this document was put together by Thomas Pokla, who is the Chapter 7 trustee, and this was dated the 20th of December, 1994. You'll please take notice. The jurisdiction. Now remember, I withdrew my consent. I discharged the debt, and if they wanted to sue me, they had to do it in state court, but they couldn't do it. They had to use the monopoly of the bankruptcy court. This notice of proposed sale is given pursuant to 11 U.S.C. Section 363B, F, J, and K, together with Bankruptcy Rule 6004, little c. The applicable local rules of this court has jurisdiction pursuant to the Bankruptcy Amendments and the Federal Judgeship Act of 1984, which don't grant them any power without consent. The only thing is you have to volunteer, and I withdrew my consent. Proposed sale. A. Thomas Pokla, bar attorney. The trustee in the above entitled matter proposes to sell by public auction at the date and time to determine the personal property described below, with the grain will be sold at the local elevator for the price that is established at the date of the sale, unless less any expenses in connection therewith. And here we list a bunch of the property, a bunch of the equipment that they had listed, and the grain, approximately 20,000 bushels of corn, another 250,000 pounds of sunflowers, and about 1,700 bushels of soybeans, and then 100 to 300 tons of hay, and I had a lot of hay, and other miscellaneous grain. And I show the pictures on some other in another setting. But the distribution of proceeds. The proceeds will be distributed in the interest relating thereto. It is believed that Farm Credit Services has the first security interest in all the said equipment and the grain, but that such security interest is small enough that with the previous sale of the cattle herein, there will be proceeds available for unsecured creditors. Farm Credit Services has agreed that any expenses in connection with this sale and any taxes which may be due and owing in connection as a result of the sale can be prorated against their share of the proceeds. Now, the court had more assets than liabilities, way more assets than liabilities. So what they did after selling all my property, the trustees had the IRS do a substitute for return on past 1040 tax returns, and disallowed all my deductions and calling the bottom line net profit, giving the IRS priority creditor status, calling to create basically a negative balance to justify their involuntary Chapter 7 bankruptcy. The bar attorney cartel protecting their theft empire as a policy. Now they sent out an analyst to analyze my debits and credits for my assets and liabilities in December, or maybe it was even November. But we sat in the middle of the yard, and he sat there and he shook his head, and he said, I've been doing this for 25, 30 years, something like that. And he said, I've never seen a case like this here. He said, you don't even qualify to be in bankruptcy. let alone a Chapter 7. So this was the ambush that they sent out. And so this is how they were using the bankruptcy court as a weapon, and this here money as a weapon to basically take me out. But I guess they had reasons, because maybe because I wasn't willing to compromise or go along with their little theft game. Okay, order approving notice of proposed action sale. This is number 6, document 6. Personal property of the estate and public auction. And this was dated January 4th, 1995. The trustee of the above entitled bankruptcy, having prepared a notice of proposed action, sale of personal property of the estate by public auction, and such having been mailed to all parties herein on the 21st day of December, 1994, and no parties having objected therein, and the time provided in the court finding good cause, therefore it is hereby ordered that the trustee sell the personal property described below by the public auction at the date and time to be established. Now, this was dated January 4th. Now, remember, it's saying no parties have objected, and we'll get to this in a little bit. And further ordered, 6A, that the trustee sell the grain listed below at the local elevator for a price at the that is established on the date of sale, less any expenses in connection with. And this is the same amount of grain that I listed before. And this is dated the 4th of January and signed here by Irvin N. Hoyt. So ordered by the chief bar attorney, bankruptcy judge. Okay, number 7. Okay, now take notice of this. This is the United States Bankruptcy Court, the judge's hearing minutes. I didn't get these minutes until later. And when I went to the court record and was asking for all these certified documents and stuff. But you'll see the date was January 5th, 1995. The time was 1 p.m. The court site was in Sioux Falls. The case title is all capital letters, Darrell A. Link. And the case number, pro se. The trustee, Chapter 7, was A. Thomas Pocola, proceeding, sale of personal property of the estate by public auction on shortened notice. And in here, it was filed by the trustee, A. Thomas Pocola, attorney, and LDO, he calls it the 3rd of January, document 158, proceeding number 17. And responses, no response filed. Lie. Okay, none. Disposition, no objections were timely filed. Lie. Motion granted under Bankruptcy Court Rule 306A3. And ordered by Thomas A. Pocola, who is asking for it, bar attorney. And here we got Irvin N. Hoyt, chief judge, signs off on it. Another bar attorney, as they got a little criminal cartel going on here. And now we go to number 8. And you'll see up on the timestamp, this was timestamped January 5th at 12:46 p.m. on that day. Now remember, the judge's hearing minutes, the timestamp was at 1 p.m. 15 minutes later. So this was all in the record prior to that hearing, and I did not know they were having a hearing that day. So I took this, we prepared this document, and I took it up there and had it filed into the court record. I was there 15 minutes before 1 o'clock. So this was in the court record when this was taken before the judge. And this is what I filed. Notice of response to documents and refusal for cause without dishonor with affidavit. Comes now, Darrell A. Link, by special appearance and visitation, and not to grant jurisdiction, and refuse for cause without dishonor the documents identified as notice of conversion to a Chapter 7 and case, chapter and case meeting of the creditors, and for order converting case from a Chapter 12 to Chapter 7, allowing trustee to gather and sale cattle of debtor, motion for the court's order allowing removal of sale of cattle, order reducing period of notice for proposed action, sale of person, notice of proposed action, sale of personal property of the estate by P. See, they didn't finish those words out. Public auction. And this is their little these are some of their little tricks. And the same are all fraud for reasons stated as follows.
Hey, Darrell, are you going to read every one of these documents?
Well, yeah, I'll have to kind of go through this here to get the gist of it. But
okay, because there's still, I just went through all of them. There's a lot more left. We're at an hour, a little over an hour, if you want to keep these digestible. You want to go through this one? Go to the next one?
Well, this kind of gets into what my response was, that we can split it here at 7, but I would like to kind of cover a little bit of this here, and then we can kind of brush a continuation if you want to do the others on another step.
Yeah, that'd be a lot better, because this is a lot to digest.
I would like to these next two little documents that I filed into the court record along with the judge's minutes.
Right.
So the same.
So let me ask you this: did any of this have any effect?
They just run over everything.
Yeah, that's why, I don't think you should read every word that's on here. Just read the title, and then tell us about, what they didn't do.
I'd like to read my response.
Okay.
My response was into the court record.
Yeah, but I mean, it doesn't make a difference, though. That's my point being. And I'm not trying to take away from your story or anything like that. And what you went through and what you lost. But for people to understand this just a lot of people don't have 12, 14, 16 hours to invest in one story. You follow me? If there's something special in here that works for somebody that you can show, it's like, okay, this will work, and it didn't because of the fraud and corruption. That's my point.
It don't work when criminals are running the court system. Right, that's the whole deal. And
Yeah.
This is evidence that will be turned in for fraud on the court. They're asking for fraud and abuse, and so I would like to make this all part of the record, and I could send them to these documents, and they can go ahead and look at the documents, because this is all evidence of their fraud and abuse in the courts. And this is how criminal justice is working. But this is very the way they're doing it, and if they can do it to me, they can do it to anybody. And they've been stealing farms, they've been stealing businesses, they've been stealing homes as a business. This is to the banks, the bar association, and they're using corporate money that they're making through the CRIS system and selling all these bonds in the cases to go out and pay the enforcement that they need to go ahead and do this. This year, I had only like $240,000 of debt, and they took the cattle and they sold them, probably got $205,000 from them. They took all the grain. They got another probably $150,000 of that, and then they sold all the machinery plus the land. This is the evidence that we don't have a justice system left. We've got a criminal cartel to operate with suits and ties under the auspices of the Bar Association that's basically running our courts and controlling and running the banks and running the law enforcement as a corporate operation, a for-profit corporate operation. And I think this is the evidence that can be laid out to basically hold them accountable and bring an investigation in on this whole thing to show that this is an example of how the U.S. attorneys have did this to the people. And they are using the courts that is financed by the tax dollars of the people and by their unknowing consent, because, you know, everybody's too busy taking care of their own lives and don't realize what's all going on in the courthouses. And when they throw somebody in prison and bring all these allegations against you and start rumors and pass them around your local community to discredit you and to character assassin you, and people that you know all your life, even your own family, have no clue of what's going on. And this is what's going on a regular basis. And, you know, and I would like, you know, to get this here kind of into the record, what these next two responses that I filed were filed prior to this here, the judge's hearing minutes. So they were all in the record. So they had notice of my objections. But, you know, I go on here where it says, you know, the undersigned has not signed any application to be in bankruptcy court effectively that would grant any evidence of jurisdiction to the court. This revocation and rescission. The case is withdrawn because it was dismissed properly. Orders are fraud and void ab initio. The court is perpetrating a fraud because it acted for the principal party, the international bankers, and I have not granted consent, and I am not the person under the scope, purview, and venue of the District of Columbia and its territories and venue of this court, and not a citizen and a resident. I had withdrawn the filing of the court and did a revoking and dismissing, in that there is no provision of the rules that permits reinstating, particularly reinstating without my consent. They are in violation of the rules, exceeding authority, and they are perpetrating an involuntary servitude in violation of the Second 13th Amendment, which is criminally sanctioned under 18 U.S.C. 1581. That the above named documents are based in fraud. The court is usurping its authority using fractional fraud and putting me in a state of peonage in total violation of the Second 13th Amendment, and no involuntary servitude is violation of 1581, which says peonage, obstruction, enforcement, whoever holds or returns any person in a condition of peonage or arrests any person with the intent of placing him in or returning him in a condition of peonage shall be fined not more than $5,000 or imprisoned not more than 5 years or both. Whoever obstructs or attempts to obstruct or in any way interferes with or prevents the enforcement of this section shall be liable of the penalties prescribed in subsection A. Number 3, all the actions of Mr. Hoyt, the bar attorney, trustees, and others are done as a result of these documents. Inducement are clearly outside the authority and in violation of clearly established law, as it appears to be evidence of well-established policy and custom. And then U.S. versus Kaminsky is a Supreme Court 1988 case which stated, we hold that the jury must be instructed that compulsion of services by the use or threatened use of physical or legal coercion is necessary incitement in the condition of involuntary servitude. And so that's what they were involved in. It is clear that they, too numerous to mention, are either threatening the use of legal coercion and actually carrying it out by attempting to compel me into a bankruptcy court that I have neither filed, wanted to continue, consented to, or could legally participate in. They are illegally attempting to force participation, and by compelling, they are placing me into a condition of peonage by the use of physical and legal coercion. None of them are a party, including all judges, trustees, federal and state, county agents involved in the unlawful seizure and sale of my property. By such actions, they are all in violation of 18 U.S.C. 1581, which creates both civil and criminal damage. In the notice is a claim given to the United States Attorney General and the Supreme Court. So we serve both the U.S. Attorney and the Supreme Court. They did nothing. They condoned this whole practice as policy. To consider, ascertain, adjust, determine, compromise, and settle. The damages were done so far are unlawful seizure of property without a warrant in the amount of $210,000 in lawful money of the United States, and for personal damages exceeding $1 million. Trustees and acting agents apparently are not fully investigated the facts. Otherwise, they would not be acting as they are. This notice is given to properly warn, fail, and cease, makes such persons liable for their actions and their personal official capacity that they will be sued for carrying out unlawful seizures, enforcing illegal and unlawful judicial orders, which tend to place me into penalty. And although the order does not require seizure of property without a warrant, the orders tend to encourage violation of clearly established law and ratify, condone unlawful seizures without a warrant. The damage was not done, not issue illegal orders, but in the execution of such. It should be clear, everyone, why Mr. Hoyt is not coming out himself to seize the property, but expects the idiots to do it. Just because the stupid idiots sign an illegal order does not mean anyone has to carry it out. This notice telling all trustees that you are fired. In fact, you are never hired. I have no consent from me, and the court has no jurisdiction. This notice is further to indicate that all of the illegal orders mentioned above and any to follow are totally refused for cause without dishonor, and will not and cannot consent to the unlawful activity in this alleged court, since the court is lawful only when the actors perform in good behavior. Failure to state by oath within 10 days how any trustees, 8B, trustees or other persons figures I am wrong, is to admit that they agree with the statement conclusions herein. Failure to cease and desist action is admission of bad faith, deliberate breach of duty, and the public display and establish the policy and custom. This letter was sent to Irvin N. Hoyt on the 23rd of December, 1994, attached as Exhibit A. So this here 8C is a letter that I sent to Irvin N. Hoyt on the 23rd of December. Dear Mr. Hoyt, as you should be aware, you have been acting outside your jurisdiction and issuing documents that several people are running around the country your orders as a basis for stealing property, seizing property without warrants, and taking property without compensation, with the use of a standing army. You know that I had withdrawn voluntarily out of bankruptcy once I found out that I couldn't be in bankruptcy court for staying purposes. You have violated your right not to contract into your court. You have assumed authority when you never had any. You couldn't possibly have any type of immunity for your actions. I hope you begin to realize your mistakes soon. Thank you for your honest consideration. Sincerely, Darrell. And that was attached to that letter. And so he had noticed, and then on January 5th, he said there was nothing in the record. There was no objections. And here, number 9, I do a continued notice of response to documents and refusal for cause without dishonor. Comes now, Darrell Link, by special visitation, appearance and visitation, not to grant jurisdiction or refuse for cause without dishonor. The documents identified as judge's hearing minutes, January 5th, 1995, the order approving notice and proposed sale, auction, sale, and personal property of the estate by public auction. Now here's where this was after I got the hearing minutes. Apparently I got them maybe the 10th of January, a few days later. And so I responded by saying the same, and same, all are continuing to be fraud for reasons stated again as follows. The undersigned has not signed any application to be in bankruptcy court effectively that would any evidence of jurisdiction or consent to this court since revocation and rescission. Case is withdrawn because it was dismissed properly. Continued orders, documents are fraud and void ab initio. The court is continuing to perpetrate a fraud because it is acting for the principal party, the international bankers, the Zionists, who are currently being exposed as part of Global 2000. And I continue not to grant consent, and still am not a person under the scope and purview of the venue of the District of Columbia and its territories and the venue of this court, not a U.S. citizen and resident. I had withdrawn the filing that the court did a revoking and dismissing, in that there is no provision in the rules that permits continued alleged reinstating, particularly reinstating without my consent. Actors are in violation of the rules, exceeding authority, violating clearly established law, and they are perpetrating the voluntary servitude in violation of the Second 13th Amendment, which is criminally sanctioned under 18 U.S.C. 1581. That the above named documents, again, are based in fraud. The court is usurping authority and proving its well-established law and custom to violate clearly established law using fractional fraud and putting me into a state of peonage in total violation of the Second 13th Amendment and no voluntary involuntary servitude, 18 U.S.C. 1581, repeated here for the benefits of those who missed it the first time. And 9A, next page, peonage basically reads the same thing as I read before. And then at number 3, said all the actions of Mr. Hoyt, trustee, and others are done as a result of the above documents, inducement clearly to be clearly outside of the authority and in violation of clearly established law and documented. And there's where it talks about this case of U.S. versus Kaminsky. And this is pretty much basically the same for the rest of this document as was on that previous notice of no consent. And if you want to go to 10, I could just talk about that. And here was the meeting of the creditors was scheduled for January 6, 1995, but I was not in the bankruptcy. I withdrew my consent. I was not in the bankruptcy anymore. And here I'll read what is underlined down at the bottom. In administration of this case says this: the trustee will collect the debtor's property and turn any that is not exempt into cash and distribute to the creditors. At the time it appears from the debtor schedules that there is no assets from any distribution can be made to the creditors. If it appears that there are assets available to liquidate, you will be notified and given an opportunity to file a claim. Do not file proof of claim at this time. I requested counting of the property that was sold, and they would never give it to me. And the next thing, here's the indictment that they brought charges against me. 10A, which is mail fraud, conversion of property, and concealment of assets. So here was the grand jury charges, and this was after the date of I had a trial on the 4th or the 5th of February in state court, where I was charged with selling 7 loads of hay that was grown after the bankruptcy was filed. And so they charged me in state court, and they felt that I was going to beat the charges, so they run up the night before after I had the trustees up on the stand. And that night they went up to Sioux Falls and got a federal indictment, and these were the charges.
Wow. Let's start right here on the next part.
Okay.
This perfect segue, because now we went from civil to criminal.
Okay, yeah, and then we can go into the pictures of the way they left the farm. So, but this is how this is all financed by the tax dollars and the consent of the people, because the people don't know what's going on, because these bar attorneys are running this here show, and they sell to people like they've got authority. They come out with their badges and guns, and one of the I could go into a lot of stories of how I was thrown around in the courts, jumped on, thrown down.
Yeah,
this is the way to make a show like they're really doing justice, because they have to label you as basically an outlaw.
Yeah, absolutely.
And all I've done, as you can see by the documents, and that's why I wanted to show the documents and to read my responses, because I was trying to. I've never raised my voice. I've never threatened anybody. All I've ever did is I responded with papers and asked them to respond and to rebut. What scared me most was when I filed that non-judicial proceeding, all done by affidavit under the penalty of perjury, and it scared the hell out of them. And they moved to the extent of reinstating the bankruptcy, converting it to a Chapter 7. The amount of money that was spent to finish this off and prosecute me and throw me in prison I'm sure was in the millions. And I looked up that case through Series 7 broker, and that case was involved in an investment that was right at $50 billion as of last year, February.
Wow, it does not surprise me.
So that sounds a lot better than trying to farm and raise a couple dollars worth of grain.
Right, no joke. All right. The Darrell Link story, that was part 9. So we're going to come back with part 10. You want to do that later this week?
We can do a continuation of part 9.
Okay. All right.
We need to do a part 9 continued.
All right.
And I filed a Title 42 action. It'll come in at the end of this here, before I start showing the pictures. And the continued version, I'm going to show pictures of basically the farmstead, what they did to the home after when I wasn't there, how they absolutely demolished it. They threw bricks through the windows. They busted everything to pieces. And what I found very interesting is there was a little coffee table, and there was a Bible neatly set on top of the coffee table. A real message to who they really hate. And I guess what I recognize is Jesus said they hate you because they hated me first. They hate truth. They hate honesty.
Right.
This is where we're at. And I guess we can thank God that we have a Savior.
Yeah, no joke. All right, everybody. That's the Darrell Link story. We'll have him back on possibly this week. If not, maybe next weekend. Everybody have happy holidays. Thank you, Darrell.
Yep. Thank you, Floyd. Appreciate it.
You're welcome. And there you have it. The Darrell Link story, the ongoing story. It's a lengthy, long story. I tell everybody, you have to beat them in court, and it's very difficult to beat them in court, because if there's fraud and corruption in the courtroom, there's no way you're going to win, because you're trying to play by their rules at their game. And they're like, what rules? Ain't no stinking rules here. So yeah, kind of stuck out like that. I've been beat up like that countless times in court. So I understand what people go through when they file all this documentation. It takes your time, money, and energy, and you just get abused. And that's what the gang stalking is all about, because this one agency needs some help with this other agency, and now you're getting double teamed, triple teamed, tag teamed. in the middle of midget wrestling and, you're losing, that kind of thing, is what it is. Don't forget, I'm still doing these. Let me give you a blackout back there. There you go. And LeFlore. This is the Specialty Trust book. It is discontinued, out of print, as you see from the banner below. Same thing for the On Trust book. So if y'all want to get an actual physical copy or an ebook, you have to act now, because once they're gone, that's a wrap. You're never going to see those books again unless they belong to somebody else that just purchased one. All these trusts will be individually in books, so you'll be able to pick them up, but just not all in one book. Currently, we already have done the revocable and irrevocable, and the charitable, not a charitable remainder. She's working on the Foreign Land and Express Trust. College education will come, as with the host of other trusts that are in the Specialty Trust book. This one. So I think some of these will be comboed, because there's I think there's 2 types of farm trusts in that book. So some are a lot similar. They're not very big trusts, so we may pack them together and make them like a 2 or 3. I don't know. That's all Ann's call stuff. If you haven't been over to the website, thefearlessfloydshow.com, Ann has totally redone the website. Go over there, check it out. Tell us what you think about it. If you like it, you don't like it, if you're confused, you're overwhelmed, underwhelmed, or just fascinated by it all and have to go through every page, knock your lights out. Ann's very proud of it. I still haven't got completely through it. I've skimmed through most of it. Looks fine to me. I'm grateful somebody else took over that duty, so that's where I'm at with it. Thank you for spending all your time, money, and energy over here hanging out with me. I hope you learned something here from Darrell. I'll have him back on. Free RICO class is coming up very, very, very soon. I need to put that together. I've got some errands to run, some traveling to do, to go places and take care of certain things. So that is on the horizon. I'm probably working around all that. Still trying to do a live seminar up in the hill country somewhere, San Antonio, Austin. So if you're in that particular area, even DFW, Waco, or anywhere in Texas, and you want to come to a live seminar, Joe Esquivel, he actually wants to come as well. So Joe's going to do a presentation. I'll put some kind of package together. So it'll be on the website. Everything will be over on the website. All the classes. We're going to have the healthcare directive and the last will and testament class coming up very soon as well. We're going to start setting up all these classes. Ann fell down, hurt herself, and has some stitches in her leg. She's, kind of incapacitated a little bit. But, yeah, we'll get it together. Time. Everybody's overwhelmed. Again, happy holidays, everybody. God bless you. I hope everything's safe. God, I just, please, can we get some peace in the Middle East? Please, pretty please. Good night.